There is a presidential tool called the signing statement. It appears in no law you've ever read. No statute created it, and it has been attached to legislation since 1830, and to this day, no court has ever forced a president to stop writing them. Here's what it actually is. When a bill lands on the president's desk, the Constitution gives exactly two choices: sign it or veto it. That's Article I, Section 7. Full stop. But somewhere along the way, a third option appeared that the founders never wrote down. The president signs the bill into law and attaches a private statement declaring which parts of it he intends to actually enforce. The law passes. The president's real position on it does not have to match the text Congress voted on. James Monroe used the first one in 1830 over a pay dispute involving Army officers. For over a century, it stayed a footnote. Then in 1986, Reagan's Attorney General, Edwin Meese, made a quiet decision that changed everything. He arranged to have signing statements published alongside the legislative history of every bill, so that judges researching what a law meant would find the president's objections sitting right next to Congress's own words. No hearing approved this. No amendment authorized it. One administration decided that private presidential commentary should carry the same interpretive weight as the law itself, and it worked. By the time George W. Bush left office, he had challenged more than 1,100 separate provisions across roughly 160 statements, more than every previous president combined. In 2006, he signed the Detainee Treatment Act, the law banning torture of detainees in U.S. custody. He signed it. Then he attached a statement saying he would interpret it in a manner consistent with the constitutional authority of the president as commander-in-chief. Translation: the ban existed on paper. Whether it bound him was now his call, made in a document Congress never voted on and could not amend. Remember, no one voted for this. Not the statement itself, not the practice, not the idea that a president's private footnote could quietly reroute a law's meaning. Congress voted on the bill. The signing statement is something else entirely, issued afterward, alone, outside the process that gave the law its authority in the first place. Legal scholars have tried to kill this for 2 decades. In 2006, the American Bar Association assembled a task force of former federal judges, including conservatives, and called the practice a threat to the separation of powers itself, warning it functioned like a one-man line-item veto. That matters because the Supreme Court had already ruled, in Clinton versus City of New York, that presidents cannot pick and choose which parts of a bill to enforce. That case struck down an actual line-item veto law in 1998. And here's the part that should actually worry you. The signing statement is completely legal. It survived that ruling untouched because it isn't a veto. It's not written into any bill. It's not a legal action a court can strike down because courts need an actual enforcement dispute, a real case, a real harm before they'll even look at it. Until someone is denied a benefit or a torture claim reaches a courtroom, the statement just sits there, doing its work in silence. This is why it cannot be repealed. Congress cannot pass a law banning presidents from issuing signing statements because the statement isn't really a legislative act. It's an exercise of the president's own constitutional duty to interpret how he enforces the law under Article II's Take Care Clause. Any statute trying to outlaw that interpretation would itself be challenged as an unconstitutional restriction on executive power. The tool is protected by the very separation of powers it's accused of violating. To regulate it, Congress would need the kind of authority the statement itself proves the president doesn't have to yield. Think about what that means for everything else you assume about how laws work. You assume that when Congress passes something and the president signs it, that's the end of the story. The text is the law, and the law applies equally to everyone, including him. The signing statement proves that isn't true. It proves the actual boundary of a law can be set afterward privately by one person, in a document with no vote, no debate, and no repeal mechanism. If this exists here, quietly since 1830, expanding without anyone's permission, what other footnotes like it are sitting underneath laws you think you understand right now?